Hi friends, Tony DeWitt here, Missouri Appellate Attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. I've never been one of those guys who like to go to the fights or see two people pummel themselves into a bloody mess on the octagon floor. I'm sure people enjoy that. I don't know why, but they do. Perhaps they've never had the opportunity to treat trauma like that, and so don't understand exactly what kind of damage they're doing, but be that as it may, that's just never been my thing. My wife taught school for 26 years, and she taught high school. And I have always told her that there would be no way I could have ever taught high school, at least not without a whip and a chair or perhaps a taser, because my general recollection of high school was that, people can be pretty crazy at times. And in the area where she taught, there were a lot of kids who were behaviorally disordered. So it was not a risk-free environment. One of her cardinal rules, however, always made me smile. And that is, she said when boys got into a fight, she could put her hand on their shoulder and say, "Hey, step back, step away. We're not going to do this. Calm down." And she could get the boys to break up. Now, she didn't step between them because she's not stupid, but she could put a hand on one of them and say, "Hey, step back." And they would do that. She always spoke very calmly, very collected, just kind of stand down, and it always seemed to work. But she said she never did that when two girls were fighting one another. She said she always called for the school resource officer to come and break it up, because the one time that she tried to get in the middle of that, she got hit. And she didn't like getting hit. With that little bit of introduction, today we're going to have another one of those lawyers behaving badly cases, and it's a bit of a doozy. And it comes to us courtesy of the 7th U.S. Circuit Court of Appeals in Chicago, and it's a case out of Chicago involving some lawyers who got into fisticuffs, shall we say. So this is from the United States Court of Appeals for the 7th Circuit. The case is Rosemary Vega versus Jesus Ramos versus the Chicago Board of Education. But the appeal is the appeal of Karen Shaw, Ann Shaw, and Donald VR. And it's from the Northern District of Illinois Eastern Division, which is Chicago. It says, Karen Shaw, an attorney for the plaintiffs in this case, allegedly assaulted opposing counsel Lisa Dreschmeyer after a heated deposition at the Chicago Board of Education building. When Dreschmeyer brought the incident to the district court's attention, the court ordered briefing and held an evidentiary hearing to get to the bottom of it. The district court ultimately concluded that Shaw misled the court about the incident and her falsehoods unnecessarily prolonged the litigation. As a sanction, she was removed from the case, and a total of 3 attorneys were required to reimburse the Dreschmeyer's reasonable attorney's fees and costs. We affirm the district court's imposition of sanctions against Shaw, but vacate the sanctions against the remainder of plaintiff's counsel for lack of notice. Now, in 2015, plaintiffs Vega and Ramos sued the Chicago Board of Education on a First Amendment case, and they said they violated Vega's and Ramos's rights under state law. And they say, look, we're talking about the lawsuit just for context because the details don't matter to this appeal. This appeal concerns the conduct of the parties' attorneys after a deposition in that litigation. Now, anytime your actions as an attorney become an appealable issue in a case, you've lost. And that's true whether you win or whether you lose the actual underlying case. Because when you do things as this lawyer did, you are going to be penalized for it. And often your client is going to be penalized through absolutely no fault of their own, other than poor selection of an attorney, I suppose. This case is more about the stresses that go on in the course of litigation. I have absolutely lost my temper in depositions, and I have, been really upset, and I've had to get up and walk away and walk out of the room and go take a breath of fresh air for 5 minutes so I can get my emotions back under control so I can go in there and finish the job. That's the smart thing to do. What you don't do is what these lawyers did. And there's some blame on both of these people because, well, let's get into that. So here are the facts. We recite the facts as developed by the parties. Plaintiffs' attorneys Karen Shaw and Donald VR met at the board's office to depose Jadine Chow, the board's chief of security. The plaintiff's third attorney, Ann Shaw, did not attend. Chow was represented by Lisa Dreschmeyer, the Assistant Deputy General Counsel for the board. Also present were Kathleen Gamble, the board's Senior Assistant General Counsel, and Pauline Stroll, a court reporter. The deposition began at 2 and lasted until 6, and by all accounts it was a tense encounter, with the board's attorney objecting early, often, and at great lengths. One of the things that lawyers should never do is object at great length, because what it looks like is you are coaching the witness. Somebody is being deposed and they give an answer that's a little longer than perhaps they should, and what happens is the defense attorney pops up and says, I'm going to object. And the reason I'm going to object is because your question is vague. It assumes facts not in evidence. When you say hit, what do you mean by hit? When you say face, what do you mean by face? Do you mean the whole face? Did she pummel the whole face? Did she go through half a face? And as a result, what they're trying to tell the witness, because the other lawyer isn't paying any attention to this nonsense, is be very careful how you answer the next question or how you answer this question. And of course, the attorney's objections are just for the record. There's nobody there to rule on them. So because there's nobody there to rule on them, at the end of the objection, in most cases, the lawyer says, now, if you understand the question, you can go ahead and answer it. And that's improper. It's always improper. But lawyers do it anyway because, for the most part, courts don't call them out on it, like they should. According to the witnesses at the evidentiary hearing, when the deposition ended, as Dreschmeyer was leaving the room, a frustrated Shaw screamed at her, asking, "What the heck is your problem?" Dreschmeyer re-entered the room and instructed the court reporter to go back on the record. Shaw responded, "No, this is personal," and moved in Dreschmeyer's direction. This is where the party's recollection of the event diverges. Dreschmeyer told the district court that Shaw physically assaulted her by pushing her out of the room. Shaw said that she was simply trying to leave the room and made unintentional contact with Dreschmeyer on her way out. By the way, since this topic involved fisticuffs, I brought in my local subject matter expert, Tony Tutos, to discuss it. Okay, let's see here. According to the witnesses, re-entered the room. This is personal. Yeah, things get personal a lot, let me tell you. Those guys get really ugly, you know what I mean? This is where the party's recollection of the event diverges. Dreschmeyer told the district court that Shaw physically assaulted her by pushing her out of the room. Shaw said she was simply trying to leave the room and made unintentional contact. What is this nonsense? Really? What? You call this a fight? Nobody got knocked down? What's going on here? You brought me here under false pretenses. I thought I was going to get to share some real opinion here. Tell you what, if I was that Lady Shaw, there wouldn't have been no complaints. You need a witness for a complaint. And, accidents happen all the time. People step out in front of garbage trucks and get hit on the sidewalk. It happens. It's the kind of thing that, just live life in the city, Anyway, I think this is kind of a silly case, just my own personal thinking. Yeah, as to the whole witnesses thing, Tony, we probably really don't want to go there. This is an actual case. What you're talking about is prescribed by the criminal law, so let's not go there, okay? Back to the opinion. Whatever happened resulted in Dreschmeyer calling the cops, pressing charges, and filing a complaint with the Office of Disciplinary Counsel, what they call the Attorney Registration and Disciplinary Commission in Illinois. Dreschmeyer brought the incident to the district court's attention the following week in response to plaintiff's motion to compel the deposition of Jesse Ruiz. Dreschmeyer's response characterized Shaw's conduct as criminal assault and battery. On the same day, plaintiffs moves for unrelated discovery sanctions against defense counsel and described the incident as unintentional contact. The district court held a hearing on plaintiff's motion on July 20, 2017. During that hearing, the court brought up the incident and stressed the need to get to the bottom of it. After the hearing, the court gave plaintiffs and defense a chance to additionally discuss this case, and defense counsel was accused of violating the rules of professional conduct, but other than that, Shaw didn't directly contest Dreschmeyer's allegations. In September 2017, the district court held another hearing and asked about the status of the ARDC and police investigations and prohibited Shaw and Dreschmeyer from participating in further depositions. Then they held an evidentiary hearing in October and November. 4 days, 4 witnesses testified. And once the evidence was all presented, the court informed the parties they'd be allowed to present any additional evidence in post-hearing briefs. Dreschmeyer's post-hearing brief deferred to the court on the appropriate sanctions, but requested at least attorney's fees and costs incurred as a direct result of the conduct of Ms. Shaw. Shaw submitted a brief in support of discovery sanctions, but did not respond to Dreschmeyer's request for sanctions. On March 28, 2018, the district court issued the first sanctions order. That order removed Shaw from the case and referred her for further disciplinary action. The court found that Shaw swore at Dreschmeyer and then intentionally pushed her with force sufficient to knock her backwards. Additionally, the court found Shaw's description of the contact as unintentional to be false and vexatious. And then they said plaintiff's counsel must reimburse defendants for the reasonable attorney's fees and costs they incurred. Almost a month later, Shaw moved for reconsideration and contested the sanctions, but at that point the court said, "No, I'm not going to reconsider this." 4.5 years later, on December 28, 2022, the court entered the second sanctions order. That order required plaintiff's counsel to reimburse defendants $11,920 in attorney's fees and costs. Now, what are the additional attorney's fees and costs that could go to $11,000? Well, you have to draft the motion for sanctions, you have to research the motion for sanctions, and you have to go and present it and argue it in court, and all of that eats up billable time. As a result, you get the bill for that, and the butcher's bill came to $11,000. That's one of the risks you take when you get into a fracas with another attorney, and both of these lawyers know that. So the court imposed the sanctions not only against Karen Shaw, but also against her partners Ann Shaw and Donald VR. And they opposed that because they didn't have notice. Neither Ann Shaw nor Donald VR had notice of these sanctions. And the district court was required to abstain in light of the ongoing state proceedings, specifically the disciplinary counsel review and perhaps the criminal case that arose out of that. Before we reach the issues for review, we must first address a jurisdictional issue. They did. They found that they had jurisdiction. And here is basically what happened. They reviewed the district court's imposition for abuse of discretion, and it abuses its discretion when it imposes sanctions and fails to explain the basis, when it doesn't properly notify the offender that it is considering sanctions, or when its decision is based on an erroneous view of the law or clearly erroneous assessment of the evidence. While we agree with the court that Karen Shaw had notice of potential sanctions, they don't agree that Ann or Don had this adequate notice, and so they vacated the sanctions against them. Now, they say that Karen definitely had notice of the sanctions. The district court correctly found that Karen Shaw was on notice of potential sanctions before March 28, 2018, and that order. And then they come down and they say, but neither Ann Shaw nor Don VR had noticed that they were at risk of being sanctioned or the reason why they might be sanctioned. Their actions were subject of no hearing, and the defendants didn't even seek sanctions against them. Shaw challenges the merits of the district court's decision under 1927. That's the statute that allows the court to impose sanctions. An attorney that multiplies the proceedings in any case unreasonably and vexatiously may be required by the court to satisfy personally the excess costs, expenses, and fees reasonably incurred because of such conduct. And that's essentially what the court found. The district court found that Shaw engaged in bad faith when she lied to the court about how the alleged assault transpired. And of course, there was a neutral witness there who was the court reporter, and the court reporter obviously told a story very similar to what Dreschmeyer said. And as a result, the court affirmed the imposition of sanctions as to Shaw, but not as it regarded the other two plaintiffs or the law firm itself. So only Karen Shaw was responsible for paying those sanctions. Now that's a pretty good result, and it's a good result because it's a shot across the bow of all the attorneys in that district or in that circuit saying, look, if you act out and you get sanctioned, don't come to us contesting the underlying evidence, because we're not going to step over the trial judge. We're going to take the view that he does. Now, if he makes a legal error, as he did here, we're going to fix that. But if he doesn't make a legal error, you're toast. And again, that's exactly the way it should be done. Lawyers are professionals. They're supposed to act like professionals. And when somebody makes you angry, you have to remember that the root word of danger is anger. And if you get angry, there's a danger you're going to get sanctioned. So if you get angry, if you're a smart attorney, you say, let's take a break. And you step up and you walk out and you go take a few deep breaths, splash a little water on your face, get a drink of water, call your wife and tell her you're having a bad day. Whatever it is, you don't get into a fracas with the other attorney. That is not going to end well for you. So there we go. Lawyers behaving badly once again. If you have any questions, drop them in the comments down below, or you can email me at the address above. Like, share, subscribe, all those things everybody else on YouTube asks you to do. I think that's fine. If you would like to do that, I would very much appreciate it. I do especially like the likes because I do pay attention to that, and it helps give me an idea as to what kinds of law videos to make. I know you guys like these because everybody seems to watch them. So, thanks again for being here. If you have the opportunity today, do a kindness for someone, make their day, and then after you have, come on back down here. We'll talk about something else fun tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.